We are here at the Shul.com podcast at the Surfside Kolel Boker, and we are reading from the Landlord and Tenant in Halacha from Rabbi Baruch Meir Levine. It's a very simple, easy explanation of residential and landlords and tenants and all discussions. We are on page 27, terms and conditions of the lease agreement. Generally speaking, once a kinyan is done, it not only binds the parties to the actual lease, but also to any terms agreed upon by the parties prior to the kinyan. Okay, even if these terms were only orally stipulated, they will very often be halachically binding. Sometimes there could be oral agreements and written agreements. Once there's a kinyan done on the lease, they both go into effect, the oral and the written. In this regard, it is important to distinguish between two types of terms that can be part of an agreement: a condition and a responsibility or a privilege. For example, when the landlord promises to have upgraded soundproofing installed before the onset of the lease, this term in effect increases the landlord's responsibility and the tenant's privilege under the agreement. However, if the tenant just stipulates that he is renting the apartment on condition that the landlord upgrades the soundproofing before the onset of the lease, this term does not give any responsibility to the landlord or privilege to the tenant. Rather, it just makes the tenant's obligation to rent the apartment conditional on the installation of the soundproofing. The practical difference between these two concepts is that in the second scenario, the landlord is not technically obligated to install the soundproofing, just that the tenant will have the right to cancel the lease if it is not installed. Whereas in the first scenario, the landlord is actually obligated to install the soundproofing. These two types of terms will now be discussed in detail. Here are the conditions of them. Generally speaking, when the parties stipulate before making a kinyan that the lease will be conditional on the occurrence of a certain event or circumstance, the halacha will so follow, even if this was only orally stipulated. On a practical level, though, it is worthwhile to put any conditions in writing, both to avoid any misunderstanding and also to be able to substantiate at a later date that the agreement was indeed contingent on such a condition. It is important to note that the fact that a party states that it is entering the agreement because a certain event has occurred or will occur is generally not sufficient indication that the parties are structuring the lease as being contingent on the occurrence of this event. It is quite likely that the party is willing to take the risk and unconditionally bind himself to the lease because he is fairly certain that the event has occurred or will occur. Only if the parties clearly indicate, or there is some form of other clear and undoubtable indication that their intention is for the agreement to be contingent on the event's occurrence, can a valid condition be established. And he provides here a good half page of sources on this in detail of the Chachamim explaining this in Halacha. Now let's take a look of a condition that a scenario that he brings in. A landlord of an apartment in the U.S. told a prospective tenant that he was willing to rent his apartment because his engaged-to-be married son decided to move to Eretz Yisrael after his wedding, and thus would have no need for the apartment. Subsequently, after the parties performed the kinyan, this son decided to stay and reside in the United States. And so the landlord now wishes to renege on the rental agreement and let his son move into the apartment. The halacha is that even though the landlord said that his agreement to the rental was because his son was going to move to Eretz Yisrael, since he didn't stipulate that the rental was contingent upon the move, so that's important, and there was no clear indication that the parties intended on structuring the lease with such a condition, the landlord remains bound to the lease and he may not allow his son to move in. This happens. I've seen this happen at least 3 times in my life, where exactly this case happened, where someone bought a second, third house, had 2-family house, 3-family house. His son said he's going to learn in Kolel, I'm going to Israel, Shana, Shniya, he wants to stay second year, third year, gap year, whatever it was. Suddenly, decided no, or his son was in Israel and decided to get married and needs a place to live next to his father, and suddenly he wants to cancel the lease that he promised somebody or of that condition. When the parties orally stipulate a condition, even if they subsequently draft a written lease contract which fails to incorporate this condition, the condition will generally remain valid. However, if the contract contains other conditions yet omits this one, this may be considered an indication that the party or parties were not insistent on establishing the condition that was oral. Some contracts contain an entire agreement clause, which states that the agreement being signed constitutes the entire agreement of the parties and it supersedes all prior agreements between the parties. Such a clause will generally be effective in invalidating any previous conditions agreed upon by the parties. So that's a great entire agreement clause having in the contract, saying that maybe we had discussions on things, maybe I said something, you said something, I agreed, you agreed, whatever is in this document is the binding document. And that's why it's very important to sign documents you agree on. A lot of brokers, especially here in Miami, they love these DocuSign documents, where they send you an email with these documents and you just click sign, 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 click, 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 suddenly you signed it. There's nowhere to make an adjustment, nowhere to make any change or anything unless you go back and make adjustments. More often than not, those agreements can't be signed. I've refused to sign so many of them because they put in there things that you don't agree upon and they say, don't worry about it, he told you, it's okay. It's not okay. Not according to Halacha, not according to state law. So before you sign, the old way of documents, if you didn't like it, you could have added a line, you could have made an adjustment, you could have changed something. And so you need to know that when you're signing these DocuSign agreements, if it's not what you agree upon, say, I don't agree to all this. Add this line or add this stipulation. A lot of times they try to throw in things in small text and font in order to sneak things in. It's the same type of scenario. Before signing a contract on a bungalow rental for the summer, a prospective tenant made it clear to the landlord that he was only willing to rent the bungalow on condition that there would be a day camp in the bungalow colony for the summer. The landlord assured him that there would indeed be one. They subsequently signed a contract which made no mention of such a condition. The halacha is that the condition is valid and the tenant is not obligated to rent the bungalow if the day camp does not materialize. However, if the contract mentioned that the rental agreement was conditional on, for example, the presence of a swimming pool in the colony, then the fact that the condition of the pool was included but the condition of the day camp was not included will likely nullify the condition of the day camp, and thus the tenant will remain bound to the lease even if the day camp does not materialize. Even when a condition is clearly spoken out, if the parties only discussed this condition at a time prior to the kinyan but failed to mention it at the time of the actual kinyan, halacha may view the fact that this condition was not reiterated at the time of the kinyan as an indication that the parties were not insistent on the kinyan being conditional on that event or circumstance. Therefore, depending on the exact circumstances, the condition may not have halachic validity. At times, even if the parties do not make any mention of a specific event or circumstance being a prerequisite to the lease agreement, the lease will still be halachically contingent on the occurrence of this event or circumstance if it was evident at the time of the agreement that the parties, in fact, intended for the agreement to be conditioned on them. So that's today's learning. Very interesting on conditions that the landlord or the tenant agree upon. Sometimes it's verbal, sometimes it's an oral, and it doesn't actually make it to the lease. But sometimes you might be right in saying it's not in the lease. Absolutely, it's not. But it does not mean you're not responsible. So that's important, and that is today's lesson on landlord and tenant in halacha.